Good afternoon, Mr. Osifowora.
Good afternoon, sir. How are you?
I'm very well, thank you. Good afternoon, everyone. We're about to start now. We're going to wait for some of our colleagues to join, but as it is now, it's 10 minutes past 2. So we'll just start and wait and hoping that others will join us as we progress.
Okay, that's
The
fine.
All right, very well. The Honorable Attorney General and Commissioner for Justice, Lagos State, Solicitor General and Permanent Secretary, Lagos State, distinguished seniors and directors. Good afternoon once again. Olamide Ibrahim is my name, and it's my privilege to welcome you all to this edition of the Lens Series. Today's edition of the Lens Series comes with a very interesting topic. We're looking at the overview of practice and procedures for divorce under the Matrimonial Causes Act. I know that is a topic that most of us will receive with mixed feelings because we live in a society that is deeply rooted in religious and cultural beliefs. And we know that majority of us would rather not even talk about it at all. But we are lawyers, and we are the ones people run to when they run into problems or when they want to get this done properly under the law. So our facilitator today is Mr. Olutunbosun Osifowora. Although he doesn't like to be addressed as a divorce expert, but I don't know how to address a person who has done over 100 divorce cases. So how do you address such a person if not an expert? So we are in good hands today, and he's a principal partner of Osifowora and Co. Without much preambles, may I invite Mr. Osifowora to take us through the topic, overview of practice and procedure for divorce under the Matrimonial Causes Act. Mr. Osifowora, you have the floor, sir.
Good afternoon. Thank you very much for the introduction. Good afternoon, everyone. Good afternoon, SARS, all learned minds. And I stand on the existing protocols. Like Mr. Ibrahim said earlier on, divorce. Maybe because of our society, a lot of people don't even want to hear about it. All we care about is the marriage. And given how much people spend on marriage these days, you don't even want to hear about divorce. And we've had all kinds of stories, but I will share a few experiences with us. And also I will share some of the things I've learned in practice. And also, I would also like to hear our own contributions so that I know I'm talking to people who are vast in law and practice. So I guess I'm more comfortable and I feel more at home doing this. So before we look at divorce, something obviously gave birth to divorce, which is marriage. And there are different types of marriages. We have marriage under the Act. We have what we know as traditional marriage. And also we have Islamic marriage. Most times people group Islamic marriage with traditional marriage. And also we have what I've called in a lot of interviews I've gone for, I call it the double-decker marriage. That is where you have people do the marriage under the Act that go to the registry, then end up doing something like maybe a nikai and also doing traditional just to secure themselves on all fronts. So these things come with its own problems, but today our focus is majorly marriage under the Act. And we'll be looking at the Matrimonial Causes Act and how it relates to divorce. All right, and all other things that it does in that respect as well. So having looked at the different types of marriages, like I said, we're looking at marriage under the Act. Marriage has been described as a contract. And like every contract, I mean, we know the elements of contract, offer, acceptance, or invitation to treat, offer, acceptance, and consideration. And the last one, which most times they play down, but it's a vital part of it, is intention to enter into legal relations. So with every contract comes what we know as an exit clause. And I kid you not, marriage is not an exception to the rule. Marriage too has its own exit clause. But the exit clause is basically in the Matrimonial Causes Act, and that's what we want to examine today. So if you look at the Matrimonial Causes Act, it actually looks at different things or different areas. You have, it covers it's called matrimonial causes because it covers dissolution of marriage, it covers nullity of marriage, it covers judicial separation, it covers restitution of conjugal rights and jactization of marriage. I know we're familiar with this, or maybe we just touch on them a little bit. Dissolution of marriage is basically what we want to look at today. Nullity of marriage, this one has to do with, there are certain marriages that are contracted, and they are marriages in themselves, but they are someone in your family and all that. That's what that actually talks about. Then also judicial separation is a variant of divorce, but with its own restraints and constraints in certain areas. Divorce basically means everybody, you go your separate ways. But with judicial separation, you haven't gone too far from each other. Then also you have maybe consummate or continue to consummate. If the wife goes to court, or if the partner goes to court, depending on who has refrained from consummating or further consummating the marriage, then the court can actually give an order in respect of restitution of conjugal rights. Then is allowed, or somebody is making false claims about marriage, then you can actually go to court and get an order against such person. So basically, that is what this is all about. So with divorce, now, like I said, we're narrowing today's topic to divorce, that is marriages under the act, or the marriage under the act, and we're strictly looking at dissolution of marriage. So we're not going into traditional or Islamic marriage. Those ones are done at the level of the customary court. But we're looking at marriage under the act and its dissolution, which basically has to do with what the Matrimonial Causes Act looked into. Now, so with every cause or action, we have to, what is paramount is the jurisdiction of the court. Now, so if we have to look at that, if you take a brief, for example, from a client, the first thing you have to determine is, where do we go with this? Do we go, what court do we go with this? How do we go about this? These are the things you have to look at. So based on the Matrimonial Causes Act, when it comes to divorce, the first place you go, or when it comes to dissolution of marriage, let's just keep it at that. The first thing you have to look at is jurisdiction. Now, where do you go? What court do you go? Now, by the Matrimonial Causes Act, Section 2(1) says that any high court of any state can actually look into this. I will share a few experiences. Because of the congestion in Lagos courts, some of us have had to go a little bit outside Lagos to file for dissolution of marriage. And most times when you serve, the first thing you hear, even from learned minds, they'll tell you that, no, the marriage was done in Lagos. What is all this? Why are you taking them to Ogun State? Why are you taking them to Ibadan? These are the things, but I think it's, with all due respect, I'll say it's just ignorance, because if they know the law, they won't come up with such argument. And so basically Section 2(1) says that any high court of any state can actually look into dissolution, can actually take up jurisdiction as it concerns dissolution of marriage. So that's as far as that goes. Then, having looked at what courts to go, so that means that if somebody got married in a Koi registry, or somebody got married, whether Ogun State registry or any local government, as long as the marriage was done under the act, then we'll have to take it to any state high court. You could go as far as Kano, you could go as far as Sokoto. We will also look at certain difficulties that may come up in that realm. But as far as we are concerned, the law particularly states that any state high court can take up jurisdiction as far as it concerns dissolution of marriage. So I think that solves the first one. Then the next thing we'll have to look at is the issue of domicile. What underscores dissolution basically is domicile. And according to the law, if you look at section 2(1)(f) and also section 2 sub 3 of the Matrimonial Causes Act, it states specifically that domicile is the basis for filing for divorce. Now, so that now takes you to, okay, we might have to look at one or two things here. Now, I've had also cases where somebody got married to a foreigner and decides to sue the person in Nigeria. And sometimes I've had, at least I could post maybe 2 or 3 correspondences where they said no, that this person lives here, this person is no longer in Nigeria, and why are you suing in a Nigerian court? As far as it's the husband that is suing, his domicile is the basis for which it can bring the action. So you can marry a foreigner from any country, all right, and at the same time, by our laws, you can actually conduct the dissolution of the marriage in any state high court, and it will be valid. The court can assume jurisdiction once you can prove that Nigeria is your domicile of origin, then that's fine. Now, I wouldn't want to go into the jurisprudence of domicile and all that, but we can just take it as it is. The law is there, the law is clear, and it's fine. In fact, there's a case, I think it's up on the screen, Koku versus Koku, where the Court of Appeal stated that jurisdiction for divorce is governed by the domicile of the husband. So that's as far as that goes. Then also, having established that any state high court can assume jurisdiction, domicile is the fulcrum of any divorce petition. We've seen case law, we've seen also the position of the matrimonial court on it. Now, the next thing now takes us to duration. Now, one of the things I've found out in the course of practice is, I will say this before I go to a story that I actually want to put up. Most times, in fact, growing up, before I even became a lawyer, I've had things like people go to court, and in doing divorce, they say some people have done divorce for 10 years. Some have done it for 5 years. Some have done it. In fact, I met someone at the High Court in Ikeja, a popular figure. Let me just skip his name. He told me that he's been involved in dissolution of marriage with his wife at Ikeja High Court there for 13 years. And I'm like, what's going on? 13 years? Like, what is the problem? Like, did somebody die for someone, or what is this? So a lot of people, in fact, most times, I know a lot of people will come and tell me that, see, I want to divorce my husband, I want to divorce my wife, I want to dissolve my marriage, but how long, the length of time is the basic problem that I have here. And I can testify to it. In fact, before I moved out of Lagos to other jurisdictions, I was involved in one, I think 2009, and judgment came out at Bushere, Lagos State High Court, sometime in 2013. Now, let me shock you. The most interesting part of it was, in fact, I will go into the story later on, but that was one judgment that was funny. The court actually did not grant the divorce. After 4 years of going back and forth, giving evidence and all that, and it was on something very funny technical issue. In fact, the court said that we came under the 1-year rule. We will still go into that, desertion. And that I can remember very well that we filed, that we said in our pleadings, that in our petition, that the husband left, that the respondent left the petitioner on the 1st of December, the previous year. And we filed on the 30th of November. So that we were 1 day short. You can imagine going through such litigation. At the end of 4 years, the court now said, so we had to go back to square one. I had to sit down and look at it and come. We can't continue like this. That what's the best way out? So somebody just told me that, why don't you try Ogun State? Why don't you try Ottawa? Why don't you try this? And now it's not as if what they do there is different or they circumvent. No. Basically what happens is that they don't have as much cases as you have in Lagos. And when I looked at the rules, and the rule states basically that any state high court can do it. That's how I found myself in Ogun State. I've had to go as far as Ibadan, but because the roads are not particularly friendly, that's why I had to come back. A lot of these matters we try and do in Lagos, but when we look at it, sometimes we just say, okay, let's push it. And to my amazement, the first time I went out of Lagos to do this, I found out that we did it within a very short time. Very contentious matter, and under 1 year we were done. But later on, when the whole traffic thing started, I had to come back to Lagos, like, you know what, let's just stay where we know and we're fine. But somehow, over time too, I now realized that I didn't know how it was done, but the section that handles matters like this, somehow there's a level of speed that has been injected into matrimonial courses in Lagos. And now everybody's coming back to Lagos and we're within areas that we know and we're fine by it. So for duration, it can be as long as possible. But coming back to having taken the brief of your client, now the first thing you do is you take the brief, then you put up a petition, you file your petition at the registry of the High Court. And once the petitioner files, signs all the necessary points where he has to, then the next thing is you go ahead and serve. One of the things I've observed generally in practice, service is a vital thing. But one thing I've noticed with matrimonial issues, particularly with judges, is that particularly when it comes to undefended cases, the judges are so keen on service to the point that even where you undertake to serve some processes, I've had judges practically cancel all the service that we undertook. And they said, you know what, let the bailiff serve. I am more comfortable. I mean, my Lord said, I'm more comfortable with what the bailiff has done, because over time, they have seen all kinds of cases. People have come back to court to write to the CJs of different states that I didn't know when I was divorced, I was not served with anything. So service is a key thing in this. So in starting, you file your petition at the registry, then the next thing is you go ahead and serve. Now, like every other every other civil matter that we do, when you go ahead and serve, then the respondent has 28 days within which to respond to the petition. Now, so within 28 days, the respondent can go ahead and file his own answer to the petition. Now, if he doesn't file within 28 days, then there's another step which can be taken. But let's look at what the respondent can do in this regard. Number one, respondent can go ahead and file his answer and debunk or confirm whatever has been put up by the petitioner in the petition. That is one. Now, but under the rules also, there's something that is called answer under protest. That is where a respondent feels that the court does not have jurisdiction over that matter, then he can file what is known as answer under protest. Basically, answer under protest has to do with challenging the jurisdiction. Now, challenging the jurisdiction of the court is one, I've seen people file answer under protest, not necessarily challenging the jurisdiction of the court, but bringing up issues such as convenience of the forum. Some people will tell you, you know, we said earlier that you can file in any court, any state high court, based on Section 2 of the Matrimonial Causes Act. But I've seen people come up and say that, it is not convenient for me to go to this court that this person wants me to go. Now, so this also happens. So, but basically what the respondent can do is file an answer debunking or confirming what has been filed in the petition, or he can come up with an answer under protest, challenging the jurisdiction of the court. Now, that is as far as the second step goes when it comes to the procedure and practice. Now, there's another thing that can happen. Having filed answer, within 14 days of filing, the petitioner can look at it and say that this person has raised now for ordinary answer, not answer under protest. If an answer under protest is filed, we have to wait for the court. The court will have to sit on the case and show to the litigants whether, and give an order in respect whether it can assume jurisdiction or decline jurisdiction based on answer under protest. Now, but where it's just an ordinary answer and is not in protest of the jurisdiction of the court, after 14 days of filing that, the petitioner can take a look at it. If there are other issues raised by the respondent, then it can file what is called a reply to the answer to the petition for dissolution of marriage. So that's as far as all the pleadings go in this realm. So when an answer is filed 14 days after they receive an answer from the respondent, then it is for the court to now wait for the litigants for another 14 days. Then after all pleadings have been exchanged, the next thing is the petitioner will go ahead and file what, based on Order 11, you file what is called Form 31. Now, Form 31 basically has to do with an undefended case. Where a case is not defended, you file Forms 31, 33, and 34. Now, that's for the undefended case. But where there's a response or there's an answer from the respondent, then one will have to jettison Form 31. You have to go with Form 32. That is to set the matter down for trial, to set the defended matter down for trial, Form 32, 33, and 34. If you don't file these forms, your case is just going to be as far as it has gone, and that's where it's going to be. So those are the forms. So once these forms are filed, then the next thing is the matter will be adjourned for trial. But I need to quickly point out something here. In the course of my practice, there was something I noticed. There are instances where, in fact, a judge had to distinguish for us one day because we filed a matter and the other party got a lawyer and they filed their answer. But in their answer, they said that they are not contesting anything. All they want to go ahead is, in fact, they acquiesce in everything we have said, everything we have put in our pleadings, and they said that they even want the divorce. So we went to court having filed Form 31, 33, and 34. And my lord had to correct us that no, that once there is a lawyer on the other side, you have to go back and file Form 32. It's already defended, regardless of the fact that the person wants what you want, or the person actually wants, or the respondent actually wants dissolution of the marriage the same way you want it. So that's as far as that goes. Now, before trial also, once you put in the forms, then the parties will appear before the court. Now, where there are children involved, based on Order 11 of the Matrimonial Causes Act, the court will order compulsorily what is called compulsory conference. Compulsory conference has to do with where children are involved. Now, where children are involved, you have to look at things that has to do with welfare and well-being of the children of the marriage. That's based on Order 11. It's called compulsory conference. Without the compulsory conference, the matter is not going to move forward. So at the compulsory conference, parties and their lawyers will sit down and determine what they want to do with the children of the marriage. They could talk about custody at that level. Who wants to have custody? How long do you want them? How do we share holidays? Then school fees, how do we pay? Hospital bills, how do we pay? All the necessary things that has to do with the welfare and well-being of the children, those things are settled at the level of compulsory conference. Where those things are not settled, then you leave yourself at the mercy of the court to go ahead and settle it for you based on the discretion of the court. Now, so once compulsory conference is done, both parties agree on certain areas. The next thing is they will go to court and file the report of compulsory conference. Once that is done, they put it in the court's file. The court will be left with nothing but just the dissolution of the marriage between the parties. That's as far as that goes. Now, so then the next thing is parties will go for trial. At trial, you come and state your case, then the other party too will state his case. Now, but in the course of practice, one of the things I've noticed over time is that where the petitioner comes and gives evidence as to evidence regarding why he wants the marriage dissolved, if there's an answer from the respondent and the respondent wants the same thing and there are no varying terms, most times once the petitioner is done with trial, the court will not allow the respondent to come on. Because in fact, what I've seen with most judges is they will tell you that, why do you want to waste my time? Your husband or wife or the petitioner already testified and you are putting your pleadings that you two want the same marriage. So it's okay. Then the next thing they adjourn for address. In some jurisdiction, they will tell you to orally address the court. In some jurisdiction, depending even on the judge, because there are no specifics in the law, in the rules governing matrimonial courses, whether you could go by written address or you can go by oral address. But the next thing is you have to address the court depending on the judge or how the court wants it. Now, so once that is done, then the next thing is judgment. Judgment is given, and that's as far as that goes. But there are instances where you have a cross petition. Cross petition as regards, I handled a matter recently at Ota High Court, and the petitioner said that the respondent deserted the home. Then the next thing, we too came with our own and said it was the petitioner that deserted. Now, so in fact, it was a virtual hearing. So my lord was like, what's going on? Why this? So both parties had to come, and unlike where I explained earlier on, where that both of us wanted it, but my lord was so interested in why both of us are coming under desertion. And you said he left, he said he left, who left who when? So that's as far as that goes. So where there's a cross petition, the court will allow for the cross petition to be heard. And then the next thing is they can adjourn for address, then eventually you have judgment. Now, after judgment, one of the things I've found out, I've had people run back to me and say, lawyer, come and help me. This man was supposed to pay school fees. This is almost half of the term. They're sending my kids away, this and this and that. Then the next thing is, how do you go about enforcing things like that? There are sometimes people come up at compulsory conferences and tell you that, okay, I'll pay school fees, I'll do this, I'll do that, I'll do that. The guy may lose his job in the course of, in fact, just immediately after you're done. Now you go to the same guy for school fees and he tells you he hasn't got it. What do you do in that instance? I think that's going to come up much later. But so far, I think we have covered from filing to what it takes to get as far as judgment. We might have to move on to the next slide to actually look at some of the things. All right. Now, so when it comes to dissolution, I know some of us may have questions, but we may note them, then maybe much after the talk, we will come up with our questions. Now, so the fulcrum of divorce. Now, I have seen processes. I mean, like it was said at the introduction, I've been involved in quite a number of divorce matters, and sometimes it's almost shameful when people just look at you and they tell you that all you do is just break home. And I tell them that, see, I don't break homes. I've seen people kill themselves when they were not allowed to go their separate ways. Now, so I'm giving life. I'm actually not breaking homes. Now, so, but when it comes to divorce, basically the fulcrum of divorce, or what divorce stands on, is Section 15, 1 and 2 of the Matrimonial Causes Act. I have seen processes, I have seen petitions, I have seen answers that are verbose. Now, when I say verbose, people just write all kinds of nonsense. With all due respect, they write things. People believe that, you know, the way you settle matters, when maybe your parent-in-law calls you and you just explain, he went here, he left home, he did not come back, he did this, he did that. You will be shocked that maybe some lawyers want to please their clients. The way those stories are explained to them is the way they put it in the processes. And you know, when you read some, you can't find anything. Now, no matter how interesting the story is, if it doesn't fall under what the law says, you'll be shocked that no matter how long you spent doing the matter, you'll be shocked that the court will just tell you that divorce not granted. And I'll tell you personal experiences, and I'll also tell you some of the things I've seen. But quickly, let's go on to Section 15, 1 and 2 of the Matrimonial Causes Act. This position has been supported by the Supreme Court, by all courts at all levels, that for you to get any form of dissolution, you must prove that the marriage has broken down irretrievably. It must be written in capital letter in your pleadings, that the marriage has broken down irretrievably. Now, in proving that, you can't just bring any extraneous story and say, okay, he did this, he did that. Whatever story you want to tell, whatever happened between the couple, you have to bring it down to the fact that the marriage has broken down irretrievably. We can't retrieve anything from this thing. And to show or to prove the fact that the marriage has broken down irretrievably, you have to go by what is written in Section 15, 1 and 2. There's a case that's up on the slide. Akinbuwa versus Akinbuwa. The citation is there. It expressed what in Section 15. If all you have written, if it doesn't fall within any of this thing, rest assured that the dissolution will not be granted. Now we start with the first one, where you can show to the court that there was a refusal to consummate the marriage. We all know what is husband sleeping with the wife, husband. I never believed this until a few years into my taking on divorce matters. And a lady came around and said that she's been married for 9 months and the husband has refused to sleep with her. And I'm like, sorry, with all due respect, what happened before you people got married? He said that they were observing their space based on their religion and they didn't want to do anything together. I said, okay, I'm sorry about that. So after marriage, 9 months, don't you stay in the same house? He said they stay in the same house. So what has he said? What is wrong? Is he impotent? The lady, we had to reach out to the man and you'll be shocked at his response. He said he was taking his time. I'm like, wow, I have heard of people who pray before going down, but I've not heard of people taking their time. 9 months into marriage and you're looking at your wife like that. We had to take it up and come under A. So then the next one is adultery. this is a common thing you hear. People storm my office almost on a daily, and they tell me that my husband committed adultery. In fact, there's a classic story I will never forget. There was a lady who came on to me and said that she saw her husband come out of a hotel, and she's sure that based on that is adultery. I said, did you see him in the course of the action? She said, no, that for someone to come out of a hotel, definitely, he didn't go there to preach. He didn't go there to work. He didn't go there to see a client. So it can be taken. I said, no, that's not the way it works. Now, I've seen people come up with this, that adultery, they even give you, stories and everything. But as simple as it is, it's one thing that I don't use under the section 15.2, and I'll tell you why. You have to go to section 30, 31, and 32 to see what the law says about adultery. If you are alleging adultery, you have to, one, cite the party, a specific party, that you can't just, adultery is never done in a vacuum. So you have to cite a specific party, that this person was seen with this person, and you have to prove it. Almost overt proof that this thing actually happened between this person. Now, so in alleging adultery as your only ground for dissolution of marriage, you have to cite the other party. So in suing now, you have to be petitioner, then respondent, then party cited when it comes to adultery. If you don't do that, you're just wasting your time. You're probably just dashing the lawyer money, because the law is, the courts are not going to grant it. A party must be cited, then there must be overt evidence of what you are alleging. Because, and I'll tell you why, you can't just sit down and imagine, the human mind is very funny and it can travel very far. So people can just sit down, maybe somebody greeted your wife somehow. I've seen people do that and say that, the way he smiled or the way he looked at that person, there's some form of connect. And based on that, you are coming to court. That is not enough. That's not going to fly. So for adultery, for you to allege or bring a ground for dissolution, adultery as ground for dissolution, you have to cite a party and you have to give specifics. If there are no specifics, then you might have to look for other reasons, because I can assure you the court won't grant it. Same thing goes for intolerable behavior. These are things that you find in most processes. People will tell you the petitioner finds it intolerable to live with the respondent because of what? Now, intolerable behavior by you is different from what the law says is intolerable behavior. That will take you to section 16.1. Section 16.1 now tells you what the court regards as intolerable behavior. And thank God we're all lawyers. If you can't link it with what has been put there, then your petition goes to naught. Now, most times for me, in the course of my practice, I would rather stay on D, E, and F. D says where a party has deserted, where the respondent deserts the petitioner for 1 year. That's very easy to prove before court. And a lot of times I'd rather just stay on this. Less story, nothing to say much in this regard. Just prove that this guy has gone, show the date, show the time, show everything, and you're good to go. The same thing applies for E. But E has a condition that your partner has gone for 2 years. Now, where that happens, then you have to, on the condition that the respondent will not come and oppose. Once there's an opposition, then the court will not allow that reason to fly. That's another one. Then the third one, this is the one I hear almost on a daily, let me put it like that. People will tell you that, if I've heard it from, I don't know where people saw this, but they'll tell you that once you have been separated from your husband or wife for 3 years, automatically you are divorced. It is not automatic. That's why I put it on the slide. There's nothing automatic about it. You have to go to court. You have to follow the process. You have to prove it before the court that both parties have been separated for 3 years. This one has no condition attached. And that's it. Now, so remember what I said earlier, maybe for those just joining us. I find, in fact, that's about the two of all of the many cases that I've handled. I've only had two instances where the court refused to grant the dissolution of the marriage. The first one was the court said we were 1 year short of the day, 1 day short of the 1 year rule. That's in what's in section 2D, section 15 2D. So the court said that we were 1 day short and the court refused to grant the divorce. Now, so in putting your pleadings forward, you have to calculate the dates. And I think the rules are there with respect to calculation of dates. Now, so then the second one, I think I'll talk about it much in the course of the thing. It was, I think, where we get to issues that has to do with trial, or I can just talk about it. The second one that I didn't have granted was some guy. Okay, it's related here too. You know, when you do pre-trial conference with clients, you tell them things. Now, divorce can be funny. Sometimes it can be emotional. I put someone on the stand before, and she started crying. Everything we had rehearsed, she couldn't say anything. I had to beg for an adjournment. We came again, it was all cries. I was like, madam, she said she was thinking about the pain and all that. So sometimes too, in handling divorce cases, you have to show a lot of empathy. You have to just come down to their level. Some people don't find it funny. And I handled one matter, in fact, in my early days, that was where I started having a rethink whether I wanted to go ahead with this. Most times, because clients can be funny, I always make sure that I take my clients along with me so I don't hear stories of I missed the court, I didn't know my way. So particularly if it's out of Lagos. So on this day, I went with this lady and we finished. She was all smiles. I think after we got judgment, she was all smiles and very excited about the whole thing. Then we got into the car. We started going, and she just looked at me and said, "Lawyer, Shotitoni." I mean, for those who don't speak Yoruba, she was like, "Is it all over?" I'm like, "Yes, that it's all over. You're fine. You're good to go." The next thing, she just started crying. And cried all the way from out of Lagos and I'm like, I can't leave this person like this. What if she's suicidal? What do I do? So sometimes it's not like normal cases where you go and you celebrate your victory afterwards. It can be funny. It may not. Some people just look at what they are put into the marriage, and with one stroke of the pen, the whole thing is canceled. And now she has to start all over again, or he has to start all over again. That's one. The other case I was going to mention earlier was some guy that we had done all the rehearsals, everything. We came under this 1 year desertion rule. The next thing, I was like, so when did cohabitation cease? He said it. The next thing I now said, okay, that under what circumstance did cohabitation cease? Guess the next thing this guy said? He said, me and my wife decided to go our separate ways. We came together and decided to go our separate ways. I saw my Lord nod his head like this. I knew I was in trouble. I'm like, this was not what we said. This was not what was written for you. At the end of the day, the court refused to grant it on one reason. Guess what? There's a part of the law that says, I think somewhere in section 2022, talks about condonation and connivance. In fact, in the course of trial, you have to ask the person in the stand that, did you connive with your wife or did you connive with your husband to get this done? And definitely the answer has to be no. So in his case, when he said, my wife and I, we came together and decided to go our separate ways, that just showed connivance. So I knew that we weren't going to go forward with it. Immediately the judgment came out, I was like, I told you, we had to file all over again, started the process all over again before we got it. So that's as far as that goes. So I think the next slide we have looked at, okay, other ones, there's G and H, failure to comply. with restitution of conjugal restoration, then absence that justifies presumption of death. Now, we all know, thank God for, we're all in the same profession. You know, I think based on law, I think it's evidence here that says that if you have not seen someone for 7 years, it can be reasonably presumed that he is dead. Now, so that's one of the grounds by which you can come. So, but basically, in doing this, you have to prove to the court that this is the position. You have to state all those things. If you failure to fall in line with what is in section 15.2 A to H, then you can rest assured that you have to start this process all over again. And God help you if you have to go another 1, 2, 3 years just to prove this. So I don't know if the slides are up, but the next thing is we go on to common mistakes that people make in matrimonial matters. Yeah, I talked about earlier, verbosity. I have seen processes. You see some petition that are this thick and all saying nothing, absolutely nothing. Now, so it is not how much you can talk. It is not all the things you can say, but it's about aligning your client's position with what you have in section 15 to section 15.1 and 2, but section 15.2 A to H. So having, I know some of us who are into this or into litigation, we've seen plenty of things like that. You wonder, is it the same case we're doing? Person will just write plenty stories, plenty nonsense. It's not very much, as funny and as emotional as matrimonial issues can be, it's not a function of how much story you can tell. It's basically what aligns with the law that will get you what you want. Then also, the second thing is, neglecting mediation. Now, let me share this with us. It's one of my unique positions. Once I get an answer, particularly when I'm the lawyer I'm the counsel to the petitioner. Once I get an answer from the respondent and I see that they want the same thing, entirely speaking, I approach the law firm and I tell them that I say, we don't need to go through a lengthy trial. And I will shock you. I've done this more than 10 times. And I've seen people practically come to court and withdraw. If we want the same thing, then why are we doing this? You first put in preliminary objection. Okay, do you want the same thing? Does your client want this thing? Then let's just come together. And it's not connivance now. This is just finding a simple way of going through this thing and finding a way around it. And we finish this thing on time. It's not, people come to court and they are sad seeing their partners. So you want to finish this thing on time and move on with it. So I see people neglect mediation. Sometimes if you approach the other people, I tell people it's not war. I've been in court and I've had cause to tell my clients that, see, that's your husband. Once upon a time, I love you. Go ahead and talk to him. Mind you, particularly when there are children there, no matter how much hurt you harbor or you nurse, you will have to talk to this man. So let's start talking now so that we can find a way around this thing. But what I'm saying in most matrimonial matters is about ego, is about hurt. Some people will tell you, what he has done, I'll never forgive him. Forget. Whatever he has done to you, once there are children there, just forget it. So explore mediation and that will help. Now then, okay, I think we touched on this, unsustainable allegations. Once you come up with adultery, rest assured that you have to put in there a party. You have to cite the party. There must be a co-respondent to this thing because it takes two to commit adultery. Adultery is not done in vacuum. Now, so intolerable behavior also, as easy as it sounds, what has been put in the law as intolerable behavior, you have to align with it, or else you have to come under a different thing if you actually want it granted. Then contested and uncontested cases. Now, where a case is contested, mediation can help and both parties can easily sort out things. Where it is not, then it's easy to go. But I've seen instances where there is no party on the other side, and divorce can be technical. Just, another thing that is simple is tenancy. You go all alone before the court, and before you know it, you will lose a case by yourself, even without anybody on the other side. Why? Because you have not complied with the rules. So it's the same thing with divorce. It has its own intrinsic technicalities, and you have to actually sit down, understand the law and the position of the law as it relates to what you're doing. Now, so another thing here is variance of testimony from pleadings. I talked about one earlier on where I saw where the guy was, it was a different thing we wrote in our petition. It was a different thing he was saying from the stand. And you know what that means in law. If your testimony is at variance with your pleadings, then something is wrong somewhere. So it's either you go and amend, take an adjournment, amend, or if you insist on staying on it, you can rest assured that the judgment won't go in your favor. Then the final one, I've seen lawyers get emotional with clients' cases. I don't understand this. I don't know why it is like that, but I've seen it several times. Lawyers get unnecessarily emotional to the point that even when you're trying to concede and you see their clients telling them that, okay, let's just agree to what they're saying, the lawyer will say, no. And I'm like, okay, it's not your case. Just calm down and let's find a way around this thing. So these are some of the common mistakes I've seen people make. And in as much as, final point now, in as much as people try to tell you all kinds of stories, always make sure that your story aligns with the position of the law. That's the technicality in divorce. If you write based on what the person has told you, he went up, he came down, he went here, he entered the car, he left it open, all those things don't fly in law. It can fly in their family meeting. I've seen people come up. Sometimes I see on blogs, they say that a man came to court and said the wife didn't know how to cook. It is not in section 15.2. So it will not fly. If your wife didn't know how to cook, go get a teacher for her. That's not a basis for divorce. I've seen even people say, I've seen some funny ones. Excuse this, it's for the sake of the lecture. They say maybe the thing has to do with activities on bed, the man has this, the woman has this one, some funny things like that. All these bloggers just come up with this. You take those things to court, you're gonna just look at yourself funny by the time the judges are through, scolding you that you say that your wife doesn't know how to sleep with you in bed. Is that a basis for divorce? You go back home and train your wife or get her a trainer or get her somebody to help in that regard. So that's as far as that goes. So, we want to move on to, I think, the next and final slide, which has to do with, I deliberately brought this up because I know it's a common thing, and I know there are departments in the Ministry of Justice that deal with things like this, and that has to do with custody. I've seen people say things like, automatically is the woman that the court will give the children of the marriage. That sounds nice. So maybe we just quickly look at those things. We look at the questions. One says, what is the governing consideration for granting of custody? Now, for custody, what the law says, section 70, specifically 70 says that what is uppermost or what is paramount when it comes to the issue of custody is the interest of the child. the interest of the child. Now, there are some instances where, excuse me, one of the things I've seen also about custody is that I've seen people fight for custody of children out of ego and not because they actually have what it takes to handle. I did one, the guy is a pilot, and he said he wants the custody of a 2-year-old. I'm like, okay, there's nothing you go. Will you carry the baby with you? Does it make sense? And you try. Sometimes you just try so hard to convince people. I had one we just finished. The guy, my client, you were asking for custody of a 9-month-old. What do you want? Will you go and get another woman to breastfeed the baby or what? When the mother is alive. Now, so all those things don't make sense. Sometimes you have to prevail on clients and actually make them see reasons why some of these things. I'm handling one currently in Abuja, and the lady called and she was trying to ask that on this issue of custody, that for now she doesn't have a stable place of her own. I mean, this was somebody who was struggling that I want my children, I want them back. Apparently the kids were with the father, and like that. And I'm like, okay, for now, since we have gone for custody, let's just stay on it. The moment you go and say you don't have where to stay, then it becomes a problem. Now, so custody basically has to do with interest of the children. What is in the best interest of the child or the children of the marriage? Those are the things we want to look at. But there's a case I bring up most of the time, particularly when my client is the female. Odogu and Odogu, the citation is there. It says point blank that where motherly care is available, where maternal care is available, you cannot deny the child that. Now, one of the things also that the Supreme Court, Court of Appeal, they put up in plethora of cases, which if you come up with this Odogu and Odogu, you see quite a number of cases there. We talk about the same thing, is that when kids are very small, okay, maybe that's tautology. Let me say, for little ones, the very little kids, the court is not always very interested in separating them from their mom. I mean, I just talked about a 9-month-old, a man fighting for custody. That's never going to fly. Now, so that's one. Then for little kids, the court is almost always compelled to give them to the mother. Now, but there's something you find in this case that is interesting. It says that if the man is rich, because some of the people, I've seen people come to court and say the woman cannot take care of them because she doesn't have a means of livelihood. That if the man is rich, that's the Supreme Court saying that. I think Court of Appeal said that if the man is wealthy and the woman has nothing, custody should still be given to the woman and let the man provide what it takes to take care of the child or the children. So the court is almost always want to give the child to the mother. That's one. But it is not automatic, because I've done like 3 cases where I got minors for the male, the male in the marriage. And the reason was this: we were able to bring up some things. Before I go to that, I've seen somebody who came to canvass. I was on the other side, and they said that the woman is not morally upright. That we're trying to bring up all sorts of things, and I told the court that, my lord, in as much as the respondent cannot substantiate that this woman, the respondent has been trying to castigate this woman and put her in bad light before the court. One, there's no evidence to show that this woman is a prostitute. And I'm like, even prostitutes, they have their own children. And the circumstance that brought them into this, they don't really want their children to go in the same thing. So that somebody is doing something in that regard does not mean you take the child from them. They take care of their own kids. Even mad people, I mean, one of the things, I mean, we grew up knowing that one of the things, hardest thing to do is a mad woman, you can't take the child away from. So if a mad woman is willing to give care to her child in the way she can, then you can rest assured that somebody who is not mad will give whatever it takes. Now, the only condition with which you could put before the court and make sure that custody doesn't go to the woman is if the woman has got maybe a communicable disease that will endanger the child of the that will endanger the life of the child of the marriage, or also if you can show to the court that the living condition or lifestyle of this person is going to endanger, because everything still boils down to the interest of the child, except you can bring overt proof of abuse or things that will endanger the life of the child with the mother. It is not very likely that custody will go to the man. So, where the woman is indigent and the man is wealthy, it doesn't change the mind of the court regarding custody. So, you could look up all cases, but then when it comes to maintenance, remedies, and enforcement, I'll quickly touch on it before I round off in the next maybe few minutes. There's a part of the law which I think that's a course on its own, and we've had cause to do that several times. I love it when the court gives judgment or gives an order, and some men just decline and they tell you that I don't like this woman, I don't like her God, and as a way of punishment, by extension, you will refuse to obey the order of court. I have had cause to come back to court and bring application to enforce the judgment of court by getting the account of the man. Not just the account, there was one we did, and somebody looked at me in court and was like, why did you do this? We had to attach both movable and immovable property of the man, up to whatever he's wearing, as part of what it takes to offset, the maintenance for the kids. And that we did, and the court granted it. We had to put it up. In fact, he sent a few text messages and we attached it. Unfortunately for the man, he said that they have not, the way they say this thing, I don't know, he's a Yoruba man, so he said they have not born the judge well. So we attached the text message, and so my Lord had to show that they born him well. So, and we were able to do that. So there's always remedy for enforcement of judgment where you have a man who declines to, follow the order of court as it relates to welfare of the children of the marriage. So that's, I think in all, so far we have looked at the Matrimonial Causes Act, and we narrowed down to marriage under the Act and dissolution of such marriages. And we said, for those of us who came late, we said that marriage is like contract, like every other contract that has its own exit clause. And the exit for marriage is divorce or dissolution of the marriage. We said earlier that there are different types of marriages. We have marriage under the Act, the ones you do in registry. Then you have traditional marriage, that's the one we call engagement and all those things. And also you have the Islamic marriage. So we said for the latter two, you do them at the customary court. But for this one, marriage under the Act, we said that only the High Court has jurisdiction to dissolve a marriage under the Act. And we said that the basis with which you come to court when it comes to dissolution, you come by way of petition. And domicile of the husband is the fulcrum of any petition for dissolution of marriage. So, and also we went on to look at the basic things you need to do. You bring your petition, then the respondent also will bring an answer to the dissolution, the petition for dissolution of the marriage. Then also we said that the respondent also has a choice. He can bring answer in protest. That is, if it's challenging the jurisdiction of the court. And also we said that you could take it to any high court, any state high court has jurisdiction. We talked about that. Then also we looked at, after the answer, if the court assumes jurisdiction, then where you have things that have been disputed, the petitioner can go ahead and file a reply to the answer. Having done the reply, we also said that service is key. Now, so a case can be defended, it can be undefended. Then also we said that the basis for which you come, or for you to actually get any marriage dissolved under the law, you have to go by Section 15 of the Matrimonial Causes Act. And Section 15(1) says that you have to prove that the marriage has broken down irretrievably. Section 15(2) now tells you all the things you have to prove to show that the marriage has broken down irretrievably. And we looked at Akimbuwa and Akimbuwa, which says that you just need to prove one. You don't need all. And I think one of the things we talked about for common mistakes is that people go verbose with pleadings. It's not the many talks. And like they say in my part of the world that too much talk doesn't really count. It's not how much you can talk, or it's not the verbosity. It's about making points. Now, and we said that whatever you say or whatever you want to do, as far as matrimonial matters are concerned, you have to bring them within Section 15(2)(a) to H. Anything outside that is not going to fly. And also we looked at the ones that are easily provable and the ones that cannot be proven. And except you bring in, because the law has alluded to some other things, and we talked about adultery, intolerable behavior, that you go as far as Section 16 to look at what the law actually says is intolerable behavior, so that your pleadings can fit into it. And also we said Section 32 also talks about divorce, that when it comes to divorce, that you have to cite the other, when it comes to adultery, you have to cite a party, that adultery is never done by one person. All right, so a party must be cited. Even adultery, sodomy, all those things, there must be a party cited by you. If that is not done, your pleading is not complete. Those are the things we looked at. Then also we looked at a few things also that can be done, that you should explore mediation in the course of your looking for dissolution too. It can help you, it can save you time. And also we said that sometimes one of the things that discourage people going for dissolution of marriage is the length of time. It can be very lengthy, but you can abridge that by reaching out to the other party. We distinguish that from condonation and connivance. And we said that basically what you do is look at where your pleadings relate and find a common ground. Then also we talked about the fact that where children are involved before trial, based on Order 11 of the Matrimonial Causes Act. So we looked at all those things, and then we said that make sure that whatever testimony during your pretrial conference, I always make sure, I don't do it on phone. I make sure you come around, we sit down, and I take you through the questions, and I tell you, okay, this is how to do it, this is how you answer. Sometimes I even throw something out of it to them, so that then also a judge wants advice, because a lot of times what we used to do in the earlier days of practice was to just make them come on the day of trial. And I got burnt twice when I said this earlier on, when I put someone in the box and the person just started wailing seriously. And let me shock you, it happened to a male and it happened to a female. So it wasn't just So I was wondering, like, okay, what's going on? They just got emotional. I had to ask for adjournment and come back. And somehow, the judges are always very liberal. In fact, one of the things I've also noticed in the course of practice with respect to matrimonial, they don't grant costs. I don't know why the judges, they are not, they're very much not interested in granting costs, whatever it is. And then also, the disposition of the court to dissolution is they're not very quick to grant it, just to protect the sanctity of marriage and the home. But they don't have a choice. The court is bound by the law. So, but most times you find out that when courts start slowing down, they try to see whether people can actually explore that area where they can, mediate and get back together. So, and I've had a case like that, and I have a friend who told me a very, very interesting story. And the story, real life story, they had, it was a very contentious case. It was a very bitter one. You know how divorce can go. So they had compulsory conference, and then they came to my friend's office, and then they talked and talked. Apparently, that was the first time they had to sit down after both parties had gone their separate ways. So, and then it was shortly before vacation. So when that happened, they spoke and they left. But there was a bit of truce that both parties reached at my friend's office. So after vacation, I think a month after vacation, the case was adjourned to maybe October or November. So my lawyer friend, brother friend called the man like, okay, we're continuing trial, blah, 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 blah. So he came around to the office. On showing up at the office, he came with the wife. The wife was behind him and he was like, Oga, why is Madam here? I mean, technically she's our opponent. So my colleague now said that. The man said, no, just don't worry. He said, okay, you come in, let Madam stay. I said, no, let come. To cut the whole story short, after that compulsory conference, love came back. And by the time they were coming back, Madam was 3 months pregnant. So obviously case had gone. So what my friend just did was he just reminded him that how you have a balance to pay. And right there, the man just wrote the check and, gave it to him. And that was the end of the case. So sometimes you may help. Don't get emotional about cases. But one of the things I don't do is if I see that there is domestic violence, unfortunately, this law is somewhat etched in. It looks like some Old Testament law. Let me permit that word. It didn't accommodate domestic violence. So that's the unfortunate part. I think when it's reviewed, and that will come in. So, but once I notice domestic violence, I don't preach mediation. If any man or any woman will raise his hands against a woman, against the partner, I don't subscribe to that. So I just go ahead, do my job, and make sure so basically in all of this, we've looked at it. We went as far as looking at custody also, and why the court is always very interested in giving custody to the female partner, because the position of the court is that where maternal care is available, the child should not be denied maternal care. The child shouldn't be denied fatherly care as well. But since it has become war, then it's best to just side with reasoning and see what is best. And like we said, Section 70 of the Matrimonial Causes Act looks at the interest of the child, and that's what is paramount. So whatever will make the child grow well with one party, that's what the court will look into, and that's what the court will grant. So I think with this, like we say in debate, with this few points of mine, I hope I've been able to, let me use the word, reach out to you. But I know we'll have questions, and I will leave it up to Mr. Ibrahim too. I saw some questions popping up, but I couldn't do the two at the same time. So I'd like to take our questions. I don't know how much time we have.
Okay, thank you very much, Mr. Osifowora. I mean, this it's been most interesting, really, because I mean, what you've done, was to take us through what I would call a master class, in divorce proceedings. I mean, just within the very short period that we have, I'm sure that every one of us can confidently say that it will not be a problem for us to take on any divorce case that comes our way. Thank you very much, sir. We were indeed grateful for this kind gesture to us. So the truth of the matter is that, I mean, one quick takeaway for me is that, I mean, gone are the days when you just receive invites to attend meetings in hotels with open arms. I'm talking about business meetings. So because from what you have described, it has landed some people into, into problems. So when next a meeting is called in a hotel, I would certainly give it a second thought and make sure that I clear all the clearables before attending. Thank you very much. Now, okay, so there are a few questions as you've rightly observed. I mean, there's one from Dr. Babajide Martins, and he is asking that, what is the position of the law when judges are dealing with children? Say some judges do so without assessors, and some do so in consultation with family assessors. What's your take on that?
All right. Do we take it one by one? Because
okay, so
I want to know.
Another one. There is another
All right,
one.
so sorry,
actually,
let me note it. Judges
okay.
and assessors.
Yes.
Or children.
Yes. There is
All right.
another one, which of course is a follow-up to that. And there's some more here. It says that in addition to the question above, in a situation where the judge holds a meeting with the children of the marriage without assessors and gives custody based on his meeting with the children, can one appeal against that judgment based on the absence of the assessor during the meeting?
Okay.
Is that taking?
Yes, sir.
Do you want to answer those ones before we move?
No, let's just take all of them. The matrimonial matters are related, so we just glide.
You're going to have, we're going to have a lot more, but okay, so there's another one where a court orders amendment to reflect the number of years parties have lived apart. Can one bring in extraneous issues like settlement of property?
Okay.
Let's take this one, then if time permits, then we'll take another.
Okay. All right. Now, see, for the issue of assessors, all right, it is safer for the judge to actually bring in people, particularly from what's it called now, the social welfare point, to actually assess the situation at both homes, all right, and also to look at the conditions, the living conditions, before actually granting custody. Sometimes I've seen judges unilaterally grant custody to a party without assessors, but it is safer, but it's not as if the judge or the court does not have discretion in that regard. In fact, the law actually gives, if you look at section 70, 71, even 72, talked about that court has the discretion to grant custody, though it must be judicious and judicially done. Now, but at the same, I mean, and we know what that means. But the fact that there were no assessors is not a basis for appeal. If you appeal based on that, then except you can bring in something serious to say that, okay, fine, if there had been assessors, this would have been done, or this would have been put in place, then, but the court has unilateral powers to do that, discretion in this regard to do that. So then, can you appeal on that? Yes, you can. I mean, you can appeal on any grounds. It's now left for the higher courts to grant it. Then there's something you said where the court holds meetings and start asking the kids. Now, you see, what I'm saying is, now there are two levels to this. In fact, at the High Court, they hardly do this. But I've seen cases, because I do a lot of child welfare cases also, and most times that is done at the magistrate court level. But with all let me look for the word now. Funny enough, I know some of us don't have. Okay, let me just leave that. I admire, particularly in Lagos, I admire the magistrates, particularly those ones who are in the child court section. But there's a name to call it, like children's court kind of thing. Who do that. Just a few of them. I guess they're always schooled in that regard. But I've seen fantastic ways of doing things by this magistrate, because they go for the assessors. In fact, they rely on what the assessors say and also bring in their own discretion. And at the end of the day, I've seen things done very well at that level. Now, but for a judge to ask kids what they want. Now, mind you, milord, milady, whoever they are, they're parents too. And they can make instant assessment by themselves. So, because I've been at a magistrate court before where it had to do with child molestation by some young man. And when the matter was adjourned, I mean, they were picking a date, and it was the magistrate who was telling us that it's a public holiday. In fact, the magistrate practically took the child, put it on her laps, and started normal motherly stuff. And so what I'm trying to bring out is that these people, they are not abstract human beings. They are not abstract beings. They are human beings themselves. And so they can do instant assessment. Mind you, they can, fine, you may say they have not been trained in the line of what the average assessor and all these things, but by virtue of their position, I don't think they are not always prone to wrong. So, but the law allows them, the act permits them to.
Sorry, Mr. Osifowora. So what do you have to say to this? Dr. Martins is saying that we also have family magistrate courts taking decisions without reference to the assessors. I still want the assessors to sign the decisions. They have no input whatsoever.
No. That is not supposed to be. That is not supposed to be. You cannot make me sign. If I know assessor should sign or acquiesce in what a magistrate has said without his own input. At that level, they have an obligation in that regard. And nobody's going to make you or myself sign something that you now say, okay, you've assessed by yourself, then I should sign. No, that won't work. That is a basis to even knock out whatever has been done. That won't fly. That shouldn't fly. That shouldn't be. That's not the way to go.
Thank you, sir. So Tonya is asking, sir, I would like to know if a subsisting marriage under customary law can nullify a subsequent marriage.
There's coming on amendment.
Okay.
And reflecting.
Okay, please go ahead.
You said that if you are asked to amend.
Yes.
On maybe cohabitation, and you now bring in, when you amend, you have to bring an application in that regard. Mm-hmm. You don't just amend and dump it before the court. Absolutely. So that your application should reflect that. And also, when you amend, you also have to display what you are amending. But you might call it overreaching, but there's no point if the court has asked you to amend in certain regard and you have noticed other things. I think it's best you just go ahead and do general amendment and seek the leave of court to have that done and point the attention of the court to it. Because there's no point amend on cohabitation, then I'll wait till we get to another thing. Then it doesn't show somebody who knows what he's doing. So you could go ahead and do all the necessaries and bring an application for seeking the leave of court to make sure that your amendment is taken. I think that's should answer that.
Thank you, sir. So I think it's a good time to answer the question posed by Tonia. Tonia is asking, sir, I would like to know, sorry, sir, I would like to know if a subsisting marriage under customary law can nullify a subsequent marriage under the Act.
Subsisting
Marriage under customary law.
Under customary law.
If it can
Nullifies
a subsequent marriage under the Act.
That is, I want to presume that, excuse me, you're married to someone else under the customary law.
Yes.
Then you now switch to go and marry someone else under the Act. Okay, now the position of the Supreme Court, I'm trying to lay my hands on it because I remember very well. It says that no marriage is superior to the other.
Okay, so Tonia is saying that, saying, to be specific, where the parties are different. So she's talking about different parties now.
No,
I mean, if the parties are different.
I got it.
Yes, okay.
If the parties are different, now, with reference to the case, I will, in the course of this, I should be able to, I have it somewhere that, but let me just answer her specifically. If you do a traditional marriage, you don't just walk away. It is recognized, it is legal marriage. The fact that it's traditional doesn't make it any less marriage to marriage under the Act. So you can't just walk away and go on. You have to disengage properly. And that is done at the customary court level. I've done a few like that at the customary court where, and it's almost the same process. What you do is you don't extend pleadings. You don't just walk away and go and marry someone else and say that one didn't exist. No. It's a big offense under the law. Traditional marriages are recognized by the law, by the Supreme Court itself. So it's not something you walk away from, that this one is superior to this. No. The one that, the case I'm looking for was saying that, was trying to distinguish that, okay, if you are married under traditional law and you also have to the same person and you're married under the Act. Now, if you want to dissolve the marriage, the Act will supersede in that regard, but not where parties are different. Where parties are different, you have to go and sort out, if the traditional marriage was the first thing you did, you have to go and sort it out. I'm seeing a question here, but I guess you will come up with them. So you have to sort that out. It's a legal marriage and it's binding on the party.
So it will be bigamy, right?
As the court pleases.
Okay, sir. So now, sorry, Mr. Odusoya, I mean, he's been trying to raise up his hand since, and I was asking him to unmute, but he wouldn't. But he has dropped his question here. He says, whatever that was discussed during the compulsory conference, can it be used against the other party during trial? That's the first question. And the second one is, how do you enforce restitution of conjugal rights?
Okay, now, for compulsory conference, in fact, there's a part of the law, there's a provision of the law that says that that whatever is discussed there is without prejudice, and you don't come back and use it. It won't fly. That won't fly at all. So, and then because there are privileged information as it goes,
so
then there's a second
thing. Used.
It can't. Outrightly, it can't.
Okay.
Then,
how do you enforce restitution of conjugal rights?
Sincerely, between you and I, let's be practical. You know, sometimes some things are more academic than. Because if the law says the husband should sleep, or there's an order that man should sleep with the wife, how do you force a man to sleep with you? Or how do you force a woman? Hey. So it's a bit.
The court can appoint an assessor.
Oh, goodness me. So it looks a bit more academic than but sincerely speaking, enforcing it, you have to go back to court to tell me, Lord, that
maybe the registrar will be involved. The court will order the registrar to be involved.
Yeah, well, but sincerely speaking, you cannot. You cannot. There's a saying in Yoruba to that effect, but it's a bit vulgar. I won't go there.
as the court pleases.
I know you know what I'm saying.
So, does the success of a petition have any effect on the chances of a cross petition?
If a petition succeeds, the cross petition goes, particularly where you are asking for. That's why I said it earlier. I think it's even in the slide that if the cross petition raises a different issue, then that issue must be looked into. Where issues are joined, normal law, normal civil proceedings, it has to be looked into. But in most cases, if for example, you say, I've been separated from the woman for 2 years. The woman brings a cross petition and say he was separated for 3 years. You want the divorce, I want the divorce. Once the petition succeeds, the cross petition goes into abeyance. Nothing is going. You want to do your own, you say, no, grant me my own separation. It's not like that. The court is not there. You cannot waste the time of the court.
Thank you, sir. So,
yes.
Thank you, Mr. Odusanya. Thank you. You could mute yourself back, sir. So, Mr. Osifowora, what factors guide domicile? I mean, considering a situation whereby we know that we live in a world where there's a lot of migration now. So there are people who are even living in certain countries without having some kind of permanent residence in those countries. So at what point do you say a person has a domicile in a country for the purpose of divorce proceedings?
All right, the case that does justice to domicile is, if you look at Bujwani and Bujwani, I think it's there. It should be somewhere there. So it's there. But basically, domicile, you have, let's do a little bit of academics.
And when we're looking at this, sorry, sir, when we're looking at this, I would like us to relate it to nationality. I mean, habitual residence.
Problem.
Everything together, and so yes, okay.
There's domicile of origin, which that one doesn't leave you. That's where you were born. Where Nigerians, Nigeria is our domicile of origin. Now, so if you take up another domicile, that is, you've gone to Canada or relocated, your domicile of origin can't be, it doesn't go into extinction by the courts. I mean, this you find in that case, because what happened in that case was the person is, I think, Malaysian, the Mr. Bujwani, or some Singaporean or something. So, but he's lived in Nigeria for a long time. Now, so the court had to distinguish between residency and domicile of origin. Domicile of origin is, it doesn't go, it doesn't leave you. If a Nigerian finds himself in Canada, even if he takes on Canadian citizenship, all right, he's still a Nigerian. The Nigerian blood is still in you. Nigeria still remains your domicile of origin. You have an acquired domicile, all right, and you're going to be there for a while, for as long as you wish, but it does not take away the fact that you're Nigerian. So your domicile of origin is more of your nationality. And by, I think, section 24 to 26 of the Constitution says that if you are a Nigerian and you acquire another citizenship, it's dual citizenship is available under the law. It's except in instances where you now take on a third one, then you might have to forfeit one for one. But being a Nigerian, you cannot say you are no longer Nigerian. So domicile of origin stands, and it doesn't diminish regardless of where you go, and it's always distinct from your new place, your new residence, or your new place of abode. So,
Okay.
so you can always allude to your domicile of origin in instances like this. Because I remember,
the
I'm
context is this, sir. So a Nigerian is in United States, for example. So in the United States, he doesn't even have, let's say it's an illegal immigrant in United States. So, but he wants to dissolve his marriage in Nigeria. So for the purpose of the proceedings, his domicile, what would the court, what are you going to push forward as his domicile?
Nigeria.
Nigeria.
Yes.
Okay. So now,
even if he's a legal immigrant, even if his immigration status is legal.
Yes.
In America.
Yes.
It doesn't take away the fact that Nigeria is his domicile of origin.
Okay. So for the purpose of
that's why you see
proceedings in
come
Nigeria
back here. Yes.
Okay. So now, what about how do we treat foreign nationals in Nigeria in divorce proceedings?
Where the foreign national?
Yeah, where a foreign national got married elsewhere in the world and the person wants to dissolve the marriage in Nigeria. How does domicile kick in?
The person got married to a Nigerian.
Let's do both. To a Nigerian or to a non-Nigerian?
In Nigeria. No.
Outside Nigeria. A foreign national got married to a Nigerian.
Outside Nigeria.
Yes. Now
to a Nigerian. To a Nigerian is the man or the woman.
What did you say?
You know the Supreme Court says that the origin of the husband.
Yes.
The domicile of the husband is what gives. So if the Nigerian is a man.
Yes.
And you got married outside Nigeria to a foreigner.
Yes.
Abi?
Yes.
That's one.
And
you can still come here and do it.
Very good.
We'll rough it.
Very good. So, but you're a woman, you're a Nigerian woman, and you're married to a foreigner. You're married to a foreigner outside Nigeria.
In a foreign land.
So you can't do it in Nigeria.
You can't drag the person here.
Okay.
Because you see, if sometimes let's be factual. If you try your luck, if they bring an application challenging jurisdiction, all the person needs to do is bring answer under protest, and that's it. The court will decline jurisdiction based on our extant laws.
Yeah. So very well. So now, in fact, what you said has just been, I've received a proof, for something that you said now. Who sent it? Nkechi Douglas says no marriage in Nigeria shall be valid where either of the parties thereto at the time of the celebration of such marriage is married under the customary law to any person other than the person with whom such marriage is had. So that's section 33 of the Marriage Act.
Okay. I saw something pop up now.
Yes.
On section 31. I think damages for adultery.
It's the same thing I'm reading. Section 33.
No. Something. Okay. Let's go ahead.
Yeah, it's section 33(1). So, and the person is, of course, leading credence to what you said earlier, that a person, a marriage act recognizes the validity of a prior customary marriage and invalidates the subsequent marriage or under the act
absolutely
for another person. Thank you very much. Okay, so
sorry, if I can quickly comment, I think it's inferiority complex that makes us feel that traditional marriages are subservient or are sub in nature to marriage under the act. It's not. It's recognized by the Supreme Court. So
Thank
it
you.
doesn't make it less any marriage. Go ahead, sir.
Okay, sir. So now, okay, looking at divorce, nullity, and judicial separation, what's really the difference between these words? I hear people throw them around.
All right. Very simple. Dissolution or divorce, dissolution of marriage.
Yes.
Hello?
Yes, I'm here. I can hear you.
Can you hear me, sir?
Loud and clear.
All right. Dissolution of marriage that's the one we call divorce. That's where two parties are married legally, all right, and then they are tired of themselves and they can prove to the court that the marriage has broken down irretrievably based on section 15(2)(a) to H, and they bring any one of those points stated there, then marriage will be dissolved based on whatever they put forward, as long as they can satisfy what is there. That is dissolution. Nullity is a variant of it, and I explain it like this. Nullity of marriage has to do with voidable marriages. Now, where you marry within certain degrees of maybe consanguinity or affinity, if you look at section 4 and 5 of the Matrimonial Causes Act, it tells you certain persons, like you go and marry your sister, it borders on incest and all those things. So, or you marry someone, maybe a minor and all those things can be brought up, that you bring you come to court to nullify that marriage, that it's not supposed to be in the first place. For dissolution, that one is supposed to be. That one is proper. All right? But parties want to go their separate ways. Then you dissolve that. But this one, you nullify it because it was not supposed to be in the first place. Now, judicial separation is the third leg of it. Now, that one means that, okay, something has happened between the parties to the marriage, and they don't want to go the way of dissolution. So the court is like an order of temporary, maybe let me call it seizure, like, okay, you know what, you go here first, you go here first. You don't change names, you don't change much, you don't change a lot of things, but you just move apart for a while, for certain things to happen, or for certain things to go, then you can always come back afterwards. Even for dissolution, immediately after dissolution, I think, okay, we failed to mention this point. You're given the judgment and what is called decree nisi.
Yes.
After 90 days, you now it becomes absolute. So within that 90 days, if you change your mind, you can come together. So that's like another shade of it is what you find in judicial separation. We're currently legally separated, but not dissolved. That is, what is it?
No. I mean, the question that was asked, that was answered earlier. There are some other follow-up questions.
Okay, yeah.
Yes. So, Ms. Ajayi is asking if the first marriage was under the Act, and there are several other marriages under native law and custom, are the customary marriages valid?
In fact, the way it works with marriage under the Act is that specifically, if you look at the Marriage Act, it tells you that once you do anything here, anything you do after it is
dead on arrival.
That's why a lot of people, God bless you. So that's why a lot of people try to avoid registry so that they can still play hide and seek.
Okay, so the truth of the matter really is that so no marriage is really inferior. Are they all on the same level, or is there one that is superior to the other? They're all on the same level.
Very much on the same level. But I explained earlier, and this is the position of the Supreme Court, that where you have done, I see people come to me and say things like, say, lawyer, come and help us. That, people always want to take the easy way out. That I did traditional, I did marriage under the Act. That's the one I call the double-decker marriage, where you say, I want to put everything together. At the end of the day, when it comes to dissolving it, it becomes a problem. So then I'll say, okay, particularly those who want to go abroad, they say, okay, can we just quickly go to customary court? You know, the customary court, they don't have wahala. They just, you can do that in 1 day, 1 or 2 days. Once you have notified the other person, all you do is pay back the dowry and everybody go their separate ways. That's how it's done there. So they listen and they do small mediation and all that. But it's very easy compared to the high court, excuse me, and all the procedure, the attendant procedure. So, but as it
Before you take
stands,
some water, sir.
I'm fine, thank you.
Okay, all right.
Now, so what people ask me, particularly people who want to migrate, they tell you that, okay, can we just quickly bring up this customary law, this customary court thing and go and tender? And I tell them that, see, if you're married under the act, the act, when it comes to dissolving that marriage, you have to go and dissolve the one you've done under the act properly. That's it. Do we have other questions?
No. I mean, we're almost through now. Actually, we have less than 5 minutes more. So okay. But I just wanted to ask this: what is the evidence of a customary marriage?
What is the evidence?
What is the evidence? Is it? I mean, you don't go to any court to get any certificate. Is the celebration, right? Is the celebration of traditional rights. That's what, that's the evidence that you have that you're married under law and custom. Right?
I've seen it. Sorry. Is Jade Simi or Jade Simi versus Okotiebo.
Okay.
It says marriages under Islamic law and the customary marriages are well recognized. Supreme Court in this country, and such marriages should not be accorded any status that is inferior to that of marriage under the Act. Supreme Court.
Well, now that I wish we could go on and on and on and on, but the truth of the matter is that we have to end this somewhere. Mr. Osifowora, I want to say a very big thank you to you for coming to shed light on these very important subjects. You see, the questions are still coming in. They are still coming in, but I guess
you send them to my mail and we will.
That's exactly what we're going to do. That's exactly what we're going to do. Thank you very much.
I saw a question earlier on. Someone asked if I am a member of RCCG. Something. I am. It's me.
Oh, okay.
So,
congratulations, sir, for
thank you very much.
Wonderful presentation of today. All right, so this is where we're going to be ending the Lens series for today. Next time is going to be explosive. Thank you for coming. Bye.
My pleasure.
Yeah.